my devices are still not working properly, and this is skeleton argument, which is just stopping on page 4. You cannot preview file after that. Probably it is about this quote from practice direction 12J, and it says that court has to ensure that where domestic abuse is admitted or proven, any child agreements order in place protects the safety and well-being of the child and the parent with whom the child is living, and does not expose either of them to the risk of further harm. While a judge ignored this practice direction 12J and moved child to live with man reported as sexually abusing her, and enabled further abuse through bullying and harassment on myself and that kind of cyber attacks. So I can't really be sure that anything that I receive on my devices is real, or is it just some, let's say, computer generated image sold as a document from the court. Because the way the documents are looking at are pretty dodgy. This is document I've received from Court of Appeal email from office worker, which I had not received correspondence from before. And as we can see, the document is looking like that. There is a seal. The seal is Her Majesty's Court of Appeal Civil Division. Right now we have a king. It's His Majesty. So apparently the king is only here on the application of mine. And this is order made by Lady Justice Falk. I'm not sure if the order is really made by Justice Falk or maybe just template. It could be also that. Permission to appeal refused and certified as totally without merit again. Judicial review reasons. Judicial review is available only where there is no adequate alternative remedy available to challenge a decision. So, as all appeals were rejected, there really is no alternative through civil courts, especially that entire practice direction 12J is simply annihilated throughout, and further abuse protected by the judge. And what it says also is that I have read the appellant's grounds, submissions, and additional documents provided, including the fresh evidence referred to in the supplemental bundle. And I appreciate that the appellant continues to have concerns about her daughter, but this cannot be addressed in judicial review proceedings. They must be addressed within the family proceedings, where they are not being addressed, and that's why I am appealing and applying for judicial reviews. The order dated 15th July was an interim child agreements order which expressly contemplated that the appellant's allegations of abuse would need to be investigated and the facts established. That is the appropriate and only route available. We have 11th of June, and fact-finding hearing was not made. Similarly, the extensive allegations against Oliver and others are not matters that can properly be entertained on these applications. If public bodies are not following procedures. That's the application that should be made. Application for judicial reviews of all actions made by those public bodies in response to CSA report. The appellant has requested an urgent hearing, but there is no proper basis on which to order that. As if protective injunction and stopping abuse is not enough of a reason. So, this is signed by the court. Not sure what court. It's not signed by the judge who made the order. So, I really have no idea what is this, because it simply looks a bit dodgy to me, with all those details that do not look like they should. Anyway, that's some other case from 2008. It's Dorby v. Corby, and how appeals usually would work would be: my Lord Thorpe, LJ, considered this application for permission to appeal on paper and adjourn the case for an oral hearing on notice, with appeal to follow if permission to appeal were to be granted. For my part, I would grant permission. So it's the same kind of problem, that if decision cannot be made on paper based on evidence, then it should be considered on the fair oral hearing, which was never allowed in case of my child. Another thing that this order said was: appellant not only had the opportunity to appeal, but in fact did appeal against the decision of Oliver dated 15th July. That application was dismissed as totally without merit, and the appellant's attempt to renew it orally also failed. In those circumstances, well, this part: that application was dismissed as totally without merit, and the appellant attempt to renew it orally also failed. The application was dismissed without oral hearing. What I've made then, when witnessing more symptoms of abuse affecting my child, was making fresh application to High Court with Form C66. It's not the appeal. And that was the hearing which I recorded because it was just looked at like a fraud. And why the judge would provide, and not any judge, we are talking about Court of Appeal, would provide false information like that. This just doesn't make sense. In those circumstances, it is not arguable that Paul J. made an error in refusing permission to apply for judicial review. He argued that remedy, which is fact-finding hearing, was to be provided on 12 September 2025. Instead of providing this remedy, the court and Oliver made the hearing, which record of I've shared already, and it's simply further abuse. Fact-finding hearing, which is remedy they all mention, never happened. And today is 11th of June 2026, and child is still forced to live with abuser.